Welcome to Washington Legal Foundation's webinar. My name is Glenn Lambie. I am the Executive Director and Vice President of Legal Studies for Washington Legal Foundation. Those of you not familiar with the foundation, we're in our 45th year of public interest law advocacy and education for free enterprise principles, the rule of law, and a limited government. In addition to doing programs such as these, our main tool of advocacy and education is through litigation, filing of amicus briefs, regulatory comments. We also have a very vigorous publishing program that we put papers out on a pretty wide range of issues, mostly written by attorneys, academics, judges, others on the outside of WLF. We also have a very well-trafficked blog called the WLF Legal Pulse. Very pleased to be doing this today. This is our second program in a series of webinars we're hosting under the theme of taking the initiative on IP protection. Each program will be a moderated discussion focused on a business or an industry's use of strategic litigation, voluntary agreements, and other proactive initiatives to safeguard their intellectual property. Today's discussion focuses on infringement of entertainment content creators' copyrights, the harms caused by such unlawful activity, and the multi-front effort to protect copyrights in the face of that challenge. This is an area that the Washington Legal Foundation has been very involved with over the years, both as an amicus curiae in the Supreme Court and in other courts. We have devoted a lot of attention to the issue on our blog, talking about good court decisions that have come down, voluntary agreements and efforts for industry to try to work together to advance a common cause. So we're real pleased to be doing this today. I'm going to introduce our panelists, but first I want to let you know that this session is being recorded. And if you have any questions for our panelists, please feel free to use the Q&A button down on the lower level. So let me up real quick. Karyn Temple is Senior Executive Vice President and Global General Counsel of the Motion Picture Association. Prior to joining MPA, she served more than 8 years in the U.S. Copyright Office, most recently as the Register of Copyrights, where she led a 400-person agency and its 8 divisions. She's also served in the U.S. Justice Department in policy and litigation roles, most recently serving the Obama administration as Senior Counsel to the Deputy Attorney General of the United States. Prior to her public service, Ms. Temple was Vice President, Litigation, Legal Affairs for the Recording Industry Association of America and was a litigation associate with Williams & Connolly. Also joining us is Jan van Voorn, who is Executive Vice President and Chief of Global Content Protection for MPA. With more than a decade of experience in intellectual property enforcement, Mr. Van Voorn currently heads up the MPA's Global Content Protection Team. Prior to joining the MPA, he had a career in law enforcement and led teams specialized in investigations and prosecuting organized and computer crime. So we'll start off our discussion with kind of what's the scope of the content piracy problem, Jan. Give us a sense for how widespread piracy is and the challenges its worldwide nature posed for MPA and others who are fighting this fight.
Well, it's truly a global issue. That's also how we look at it, and I will dive into that a little bit later. But it's truly a global issue. We are, with the whole investigation team at the MPA and ACE side, landscaping these issues globally every month. We have up-to-date landscapes. We prioritize them in terms of piracy buckets, kind of what is out there, streaming website piracy, illegal subscription streaming services, for example. We break down the world in terms of targets and then look at where the operators of these services reside. I think, that's an important exercise because that kind of determines prioritization and making sure we are going after the worst of the worst targets that are really impacting creation next to economies. But the challenge to your question really is anonymity. These people do business online, anonymous. They try to hide in anonymity. So they use different intermediaries. They run their illegal streaming business, can reside anywhere, and then try to do that in anonymity. And breaking that anonymity and going after these operators is a challenge we are fighting every day and are going after them every day, all day, 24/7. It's kind of a summarized way of explaining this, Glenn.
Get deeper into it, certainly. So what's the economic impact of this kind of illegal activity, Karyn? How does the piracy that's going on out there impact consumers of entertainment content?
Thanks, Glenn, and it's a pleasure to be here. I'm going to actually try to share my screen real quick as we have a couple of slides that we can that will go into a little bit more detail on some of the themes and the statistics that we're discussing. Hold on one second. And is everybody seeing that? Great. Well, I mean, I think, of course, many of us do know the numbers in terms of the economic impact of piracy. You know, it's not hundreds, it's not thousands, it's not even millions. It's in the billions in terms of the harmful impacts of piracy on our industry and on our economic growth. You know, of the nearly 136 billion visits to film and piracy websites last year or in a year, those cost over 230,000 jobs and nearly $30 billion to the U.S. Industry. And these, you know, and I think as Jan will mention, you know, these billions of dollars, you know, aren't going to our neighbors and friends down the street. They're going to the real life Tony Montanas of the world, the real life mobsters who are engaged not only in illegal piracy of entertainment content, but also in money laundering, in drugs and tax evasion. And, you know, it really does have a real world impact. That's the other thing I wanted to highlight on a multiple number of individuals and participants in the overall content ecosystem. Like everything, I think, you know, the film industry, it's a numbers game. And for that one profitable film, there might be 20 films that are just not profitable. So when budgets are tight, you often will kind of lose the ability to potentially have that next great film because you'll be focused on films that you don't want to take a risk on those films that the big box, you know, office films that, you know, are, you know, like the sequels and others that, you know, will do well. So when piracy decimates, you know, the industry, it actually affects the films that you're going to be able to see at the box office, because you're not going to be able to necessarily see those art films, art house films, those indie films. And it also not only affects the kind of the studios, large and small, but it affects beyond the studios, everybody who could be working on those films. So from the caterers to the makeup artists to the hairstylists, those people are going to lose jobs from not being able to work on a film, as well as the state economies where those films might be actually set and be made. I think one, you know, example of this a couple of years ago, a group of film artists and producers wrote a letter to Congress, and they referenced the Academy Award-winning film Moonlight. And, you know, they noted that, you know, that film made, you know, not $65 million in worldwide theaters, $9 million in ticket sales in the United States, but it had $60 million in piracy transactions for that one film. And that was 650% more than the paid tickets for that film. And if just a fraction of that amount, just 5% of that amount had been paid, you know, to the legal theater, then that would have given that film more than $21 million of box office. And again, for independent films, that's make or break in terms of being able to get that next film green lighted. So it really is not just kind of the billion-dollar number, it's the real world impact in terms of the people who are working in the film industry, as well as the type of films that are being able to be made, that piracy really does have that really negative impact on.
I think one of the unintended consequences of the fact that movie studios like Marvel now put clips in the end credits and sort of force people to stick around to see the credits as they roll by. And it's just astonishing how many people are required to make a film like that. And I certainly hope that as people wait around for the first and second end credit scenes in the next Marvel movie, they really pay attention to how many people are there. It's overwhelming, really. It's incredible how many
film industry,
in
the film industry, that it takes a village is certainly very, very true.
So, Jan, MPA is involved in a number of different piracy coalitions, working with partners from other industries that rely upon content. one of the leading ones that you're involved in is the Alliance for Creativity and Entertainment. Can you tell us a bit about how ACE was formed, what the coalition looks like, and how does it address anti-piracy work for its members?
Sure. When I started with the MPA in 2013, I was tasked with centralizing our enforcement actions and also building a larger future-proof team that can deal with digital piracy cases. So we kind of stepped away from being in every country with no real strategic reason anymore, because the trend really shifted and changed and needed a different approach. So while we were doing that, fast forward 2-3 years and getting more cases in our investigation pipeline, in our case pipeline in general, we kind of noticed a lot of duplication of effort across many other companies around the world. And that's kind of really the genesis for the idea to do more together, to really avoid that duplication of effort and build a global coalition that actually can deal with all these issues, but do it together in a more cost-efficient way. But more importantly, I think in a far more impactful way, really kind of looking at doing this together, bring all the data together and looking at the targets connected to my landscaping comment I made at the very beginning and make sure we bring that into action. So in 2017, mid-2017, we formed this alliance. The MPA formed this alliance together with Netflix, Amazon, and the 6 MPA members being the governing board for ACE. And we brought on board 26 members in total to launch ACE again in mid-2017. This coalition is very much focused only on content protection and litigation work, as we will talk about some of these cases and what we are doing on a day-to-day basis. But it's really driven by the MPA team, the investigation and legal team, under Karyn Temple's leadership, where we try to be effective around the world. To again, my first point, this is a global issue and it needs a global approach. And by bringing all these partners together, we kind of learn every day that we are getting more effective as we learn from our previous actions around the world. Right now, we are heavily expanding ACE. So we are in discussions with the sports leagues. We are seeing a lot of overlap in terms of targets. For example, these illegal subscription services I've mentioned, where you pay $10, $20, or whatever the currency may be. You get thousands of TV channels, all the VOD TV content in the world, as well as all the sports content in the world. So joining forces with the sports leagues is what we think is important, and making sure we address that target overlap by being more effective by have them part of ACE as well. So we brought in one sports company, Be In Sports, and are working together with them since April this year, as these new tiers were recently approved by the board. And we are now heavily expanding, as I've mentioned, this sports tier, as well as the strategic tier we have developed as well over the last couple of months. We are looking for strategic partners in ACE, where we think we can be more impactful together in countries like Southeast Asia, Vietnam, Thailand, to name a few, as well as Latin America. So you might have seen a few press releases out there that we have brought on View, a Southeast Asian streamer based in Hong Kong, as well as True Visions, a content company, as well as an ISP in Thailand. But we are now onboarding many more companies to, again, execute on the vision I've explained to you all here on this call, and really be more strategic on the ground. To kind of go to law enforcement with these companies is far more impactful than us flying in from Los Angeles or from Brussels or from wherever the country may be. But to go to law enforcement in Germany with the leading German content creators, or in Thailand with leading local Thailand-based content creators, is absolutely key to success, to talk to local governments and again to law enforcement, like I've mentioned. So that's really kind of the vision we have for ACE, and the expansion is very recently approved. So you will see a lot more announcements by the end of this year, actually in the coming weeks to the end of this year and beyond, because yeah, that's a big mission of Karyn and myself right now.
Jan, talked about with Karyn a little bit the impact on consumers of piracy. The Digital Citizens Alliance recently released a report that showed the connection between consumer visits to pirate content websites and the safety of their hardware and their personal privacy. Jan, what did that report conclude, and what does it mean for the fight against piracy? Piracy, excuse me.
Yeah, I mean, it really confirms what we already knew, really. It's just really important to kind of do this research and kind of have that research out there that kind of reconfirms what we already expect and what we kind of know to a certain extent. There are clear links to malware, viruses. There are these websites where you go to if you're visiting illegal content websites, and you will get pop-ups, pop-unders, install this virus scanner. And yes, there are malicious ads, and you get stuff on your computer that you don't want. Next to indeed now this new report from the DCA that clearly confirms connections with piracy websites and ransomware. Clear investigations they have done. They went to these websites, and these machines, these virtual machines they have used, these investigators and researchers got infected with ransomware. So another clear link that these piracy servers are bad. And as Karyn mentioned right at the top of this meeting, we are not talking about some kid in the attic trying to run some service and is doing it for the greater good. 99.9% of these cases are bad guys. You're not talking about any kind of activist here or whatever it was, what we heard like 20 years ago. These people are in there for the money. They're organized. They try to hide in anonymity, and they make millions. And they don't care about anyone that comes to their website. They really just want to make money. If they can do it via malware, malvertising, viruses, and ransomware, they will do that. If you go to these illegal subscription services, like I've mentioned, for example, against a service where you pay $20, TV channels, VOD, and sports content, you are giving your credit card details to a person you don't know, persons we are investigating, and they're not nice people. They're organized crime mobsters, next to them having large rap sheets, criminal history, felons. We have seen it all across the many cases we are running around the world. So consumers should really think 5 times. And really, if it's too good to be true, it's too good to be true. These people are in there to make as much money as they can, to run their illegal service, and then buy fancy cars, buy fancy mansions, and then show off their wealth online if they can. It's really important that the consumer sees this as a really big risk. So I'm glad kind of fighting the good fight in terms of protecting content. And as Karyn mentioned, hard work goes into creating these movies next to kind of make the consumer aware that there's a real risk that you get bad stuff on your computer and you're exposed, and you expose your credit card details big time when you deal with these guys.
If you're interested in reading that Digital Citizens Alliance report, I've put a link to the report itself in the chat if you'd like to take a look at that. So, Karyn, litigation against those that enable content piracy, from businesses that manufacture set-top boxes to those who maintain websites populated with links to unauthorized content streams, have long been a part of the anti-piracy effort. Have MPA members found tangible success with such lawsuits in the past decade or so?
You know, that's a great question. I'm going to have to say a qualified yes and no. Yes, we have successfully sued a number of services in the United States and elsewhere, and we're able to, you know, when we are able to find those individuals and bring them to court, we're able to, you know, get substantial damages. In the last, you know, 3 years or so, we've been able to sue various illegal services and get settlements, you know, more than $100 million. As you know, when you're talking about copyright infringement, you know, you have statutory damages that can go anywhere, you know, up to $30,000 for regular infringement to $150,000 per work for willful infringement. And typically in our cases, we will often have, you know, hundreds, if not thousands of works that we would be able to claim and get damages on. So it's yes that we've been successful. We've been able, you know, to go after streaming, you know, the services that provide it, you know, streaming devices. We've been we've gone after, you know, IPTV services, illegal websites in the United States. The no caveat is that, you know, as piracy continues to flourish, as technology advances, as pirates you know, become more sophisticated, we see that we're seeing more things overseas, and that we have to regularly, you know, work not only in the United States, but effectively through our whole global network to be able to find and go after our the opponents of legitimate services. And, you know, I'll say that's why the Motion Picture Association, you know, we're not just a, you know, as Jan mentioned, we're not just a US-based organization. We not only have investigators throughout the globe, we also have lawyers throughout the globe. Right now, we actually have probably more cases that are filed overseas than we have cases pending in the United States. Because, as I think one of the quotes said from one of the articles out there, we will find you and we will go after you. So our litigation efforts are successful in terms of not only being in the United States, but also overseas. But again, it becomes harder and harder as those overseas defendants become more anonymous, hiding behind other services, not having to provide their information when they're utilizing legitimate services on the internet, and also just when they're going to countries that we aren't able to effectively enforce in. So those are the difficulties that we face in terms of our litigation approach.
With that in mind, since many of the perpetrators are foreign nationals, it's difficult to bring lawsuits against foreign nationals in the United States. How have federal courts ruled on content creators' attempts to sue overseas defendants in federal courts?
Another great question. I think, as I said, this is critical for us to be able to go after the defendants in the United States, even if they might be based overseas, because what you see is a lot of pirate services going overseas after we're able to get them in the United States, but still directing their illegal services at US consumers and harming US businesses. I will say the case law is still developing in this area. So it's really important for us to get involved in all cases that kind of relate to both kind of substantive case law as well as jurisdictional case process kind of based case law on these issues. We did have a very good case decision in 2018 that would have, I think, it been a watershed moment in the negative if we hadn't been able to be successful in that particular case. And that was a case that the DC Circuit decided in 2018 against a Polish streaming service that was based in Poland, but was streaming to US customers. And the question was whether the US Copyright Act even applied to streams that originated, in Poland, but that were streamed to the United States. Fortunately, the DC Circuit ruled that, in fact, yes, US copyright law did apply to streams that, public performances essentially that originated overseas and were streamed into the United States. But if that case had gone differently, that would have obviously really cut off a very important way that we enforce our rights. And then even if you have substantively the US copyright law applying, then you have jurisdictional issues. So US copyright law applies, but does the court have jurisdiction over the defendant illegal websites? And I will say the case law, again, is still developing in that area. We recently submitted an amicus brief in the Lang Van versus VNG case in the Ninth Circuit, which was a very important case for us. And just a couple of weeks ago, there was a very good decision, and that was basically saying that essentially the federal long arm statute did provide jurisdiction against those illegal services that are based overseas, but are aiming their services at US, consumers. I will say there are other cases that we kind of disagree with. The AMA Multimedia versus Wanat case. It's also in the Ninth Circuit, but it went a different way under the same, federal provision. So that just shows how the case law is still developing in that area, and how important it is for us to get involved and ensure that, again, we're able to utilize the tools in the United States against foreign services overseas that target the United States.
We're fortunate to have the three attorneys who represented MPA and their partner organizations on the amicus brief do a paper for Washington Legal Foundation on the Ninth Circuit decision that Karyn was just mentioning. That link is also in the chat if you'd like to take a look at that. One of the key things for those who do bring litigation is, what's the remedy in these kinds of cases? What kind of relief do courts order in successful digital content copyright lawsuits? Karyn, the measures like ordering ISPs to block defendants' access work, or is it getting to kind of more of a whack-a-mole situation?
we often talk about the whack-a-mole situation. We typically talk about that with respect to the DMCA in terms of takedown notices, which is not very effective in terms of really permanently stopping piracy. And so while we engage in our, among, other industry players who send millions and millions of takedown notices every day to, ISPs, I will say that, we haven't found that is not the silver bullet, so to speak. In terms of civil litigation, again, we are effective when we're able to find the defendant, especially when they're located in the United States. We are able to have a court directly order that defendant to stop, to get an injunction to stop the infringing activity. So that's one of our primary asks in any civil litigation. Tell the defendant to stop their activity, and then we often get significant damages. Statutory damages, as I said, can be very, very high, and we've gotten hundreds of millions of dollars in statutory damages against those defendants. The record companies have gotten billions of dollars in statutory damages against defendants. So those are the tools we use. I will say, and you mentioned, no fault injunctive relief. That is another tool, or site blocking, so to speak, is another tool that we utilize. We don't utilize it in the United States because, there's not currently a specific provision in the United States copyright law that allows us to do so. And so it hasn't been something that people have regularly done in the United States, but we have a very effective enforcement program overseas, where there are a number of regimes overseas, a number of countries that have site blocking regimes. Site blocking either that have been established through case law, so where we are able to sue and say that, under the existing precedent, we can, the court can order a ISP to block access to an illegal service. Some regimes have administrative site blocking, where there actually is a separate process that is created by the government to engage in site blocking. And then there are some criminal, enforcement methods that we're able to utilize in some countries. Right now, we have a huge number of countries that are engaged, and I actually have a slide on that, which I can show. We are working with countries all the time about, whether this is something that would be effective in new countries. But over the course of the last several years, we have blocked, thousands and thousands of domains, more than 20,000 illegal websites. Site blocking has been established, as I said, in those kind of three methods in nearly 40 countries. And what we found is that some of the issues in the past that have been raised in the United States when we've been considering legislation on this have really proven to be red herrings. We have found that the site blocking processes in these, nearly 40 countries that we are active in work well. We actually cooperate with the ISPs in a voluntary way in most of those countries as well. There haven't been significant issues of over blocking or censorship, and the internet still is in existence. There haven't been any significant internet infrastructure concerns that, again, have been raised previously when the United States has looked at site blocking legislation. So that has been one of the most effective tools that we have been able to do, combined with directly suing the individuals. But if we can't find the individual defendants and go after them, the next best thing is for us to be able to get a default judgment against that defendant. We know that we're not going to be able to get any compensation. We know that the court, even if they enjoin the defendant, it's not going to be operative because the defendant didn't appear. But working with ISPs overseas, getting those sites blocked so that access is not provided to those illegal services.
Yeah, and how much does working with law enforcement ahead of this kind of civil enforcement activity play a role? I imagine finding the targets, certainly law enforcement overseas especially, must play a pretty significant role.
Yeah, absolutely. I mean, there's no greater deterrence than a law enforcement action. It doesn't matter what country we are talking about. So working together with law enforcement is extremely important to us. I think just to take a few steps back, it's important for the group to know that we are engaged in a lot of self-help. We are looking at all these cases, the landscaping I've mentioned, and then first we look at what can we really do ourselves and how can we get an effective action in whatever the country might be, or everything Karyn just presented in terms of escalating it to civil litigation or looking at site blocking around the world. But at some point you reach a dead-end street, you identify someone but not the whole group, you deal with difficult jurisdictions, you're dealing with organized crime, they're armed and dangerous, they have, again, to my earlier comments, felon charges behind them, whatever, again, the case may be, every case is different, then we escalate those cases to law enforcement. And again, to Karyn's point, this is global, so not just in the United States, to law enforcement units where we identify or have links to suspects, for example. So when we kind of escalate those cases to law enforcement, we work hard on good files. So these files are from A to Z, identifying the infringements, are identifying the operators as much as we can identify them, the way the service works. We kind of are there all the way, again, from A to Z with law enforcement to provide help, to show up in court if that's necessary, really work with them hand in hand. And maybe for a little bit more context, that we have actually someone embedded with HSI, with Homeland Security, the IPR Center in Washington, DC, someone that is working on our ongoing criminal cases in the United States with Homeland Security field agents that are working those cases together with federal prosecutors in the field, as well as City of London Police. They have a dedicated intellectual property crime unit. We have 3 people seconded there that are supporting law enforcement with IP cases, as well as working with local high-tech crime units in Portugal, for example, but also in Bulgaria. I mentioned Asia Pacific, Latin America. When we escalate those cases, we are there as MPA, but also as ACE. So for them, it's really easy and helpful to work with us because we represent 42 ACE members right now. And to my earlier point, this is growing rapidly. So it's a nice one-stop shop for law enforcement to work with us. So if they need a witness statement, if they need specific data points, we can actually work very effectively and quickly with them. But just to kind of emphasize this point, extremely important in our strategy setting, looking at all these cases, what can we do ourselves, and then working with law enforcement being absolutely key. Again, not just in the United States, but around the world to get that deterrent message out. We feel what we are doing is moving the needle to the whack-a-mole point. We are not seeing that everywhere. We are seeing when we address these services, they actually stay down and they don't reappear in terms of these operators coming back online when we have addressed them and they sign the settlement agreement, for example. There's always someone who tries again, and we will address those accordingly as well. But working with law enforcement needs to be connected to our global strategy. It's reaching out to these operators, breaking anonymity, visit them, tell them to cease and desist, transfer domain names, sign a settlement agreement. If they don't want to settle, if they don't want to shut down, then escalate it to the legal team to bring civil litigation if that's the right way to go. If that's not the right way to go, or there's a better way to reach some kind of relief here, go to law enforcement and work with them by bringing those cases, again, in whatever the country may be, is a very effective escalation strategy. So yeah, with regards to those embeds I've mentioned in the UK and in the United States, extremely helpful, but that's not just limited to those 2 countries. We are working with Europol. Europol has now a dedicated IP unit for a few years, which is really important for us as internet piracy, digital piracy spans borders. So it's not just you deal with a case in Poland. No, they have a suspect here and there, 2 countries. Infrastructure is in another country, in France, for example, and they use payment service in the United States. Kind of working together with HSI, like I've mentioned, Europol that spans those European countries is key to kind of really drive those cases to success. Do timed and time coordinated actions to not make sure that you shut it down completely and you're not address just one part of the operation, but you shut it down as a whole is extremely important. And last thing, just in terms of law enforcement, is Interpol. Interpol has a dedicated IP unit now for 1.5 years. We are working very closely with them, addressing cases outside of Europe. I've mentioned Vietnam. We are seeing more operators of illegal streaming websites in the English language being located in Vietnam. They run very sophisticated illegal streaming services with as much as 80, 90 million visits a month, of which roughly 2/3 come from the United States. Those need to be addressed by law enforcement, doing that locally with HSI, the IPR Center in the United States, and with the help of Interpol, we can really move the needle in that space. It's really teamwork around the globe for sure.
Thank you for the elaboration on that. I think it's really important to understand the scope of what you're doing. One of the copyright laws in the US that's really placed prominently in this is the Digital Millennium Copyright Act. Its implementation by the US Copyright Office and a section of the law itself are the subject of a First Amendment lawsuit right now, Green versus DOJ. There was an oral argument in the case in the DC Circuit last month. Saw that NPA and others participated as amicus curiae in that. What are the plaintiffs arguing there, Karyn, and did the arguments give any indication of how the court will rule?
Yeah, no, that's again a great question. I would say, you mentioned our amicus brief in that case, and I think the coalition that filed that amicus brief, it wasn't just the Motion Picture Association. We also had the Recording Industry Association, the Entertainment Software Association, the Association of American Publishers, and the News Media Alliance on that brief, I think showed the critical nature of the Section 1201 provisions to the entertainment industry, and the importance of making sure that the court gets this one right in terms of upholding the constitutionality of Section 1201. The plaintiffs are essentially arguing that the Section 1201 anti-hacking provisions that prohibits hacking into digital locks on content that is distributed online are unconstitutional, and that the process that the Library of Congress done with support of the U.S. Copyright Office in terms of providing specific exemptions to some of those access prohibitions is unconstitutional. And we argued in our brief that these provisions really allowed the internet distribution that we know now in terms of the rise of streaming to take place. If we didn't have a way of protecting the content online in some way and providing some type of digital rights management, we wouldn't have all of the wide variety of creative content that we have online, because there would be no way of actually really monetizing and protecting it. So that's something that we noted in our brief, and in terms of the fact that all industries, not just the film industry, need to protect their content online in some way. The plaintiffs are arguing it's a somewhat complicated case procedurally. There are two separate plaintiffs that have slightly different arguments, but essentially they're arguing that the Section 1201 provisions are unconstitutional, basically on their face, that they violate the First Amendment free speech protections, that computer, in the issue in that particular case is essentially being able to hack into computer code. The plaintiffs are folks who say they need to reverse engineer computer code for research purposes and to testing security. And so they're arguing that first, that computer code is itself speech under the First Amendment, and that the prohibitions that you have under Section 1201 are unconstitutional that there are basically content-based speech restrictions subject to either strict scrutiny or intermediate scrutiny. I would say, I think we were pretty pleased with how the oral argument went a few weeks ago, in the sense that from my perspective, and I think some additional folks in the industry who listened to the oral argument, it didn't seem as if the facial challenge to the law was something that the courts were really buying, that 1201 is unconstitutional on its face. Again, there's some procedural issues as to whether the plaintiff, or at least one of the plaintiffs, even has standing in the case. So we'll see if the court gets to the actual constitutional issue. But I think that we feel pretty strongly that the questions express some skepticism that this provision that has actually worked very effectively for many, many years. We're on our eighth, the Copyright Office is on its eighth triennial rulemaking under Section 1201, which provides these exemptions to allow certain, hacking essentially, that actually has been a process that has worked well. We pointed out in our brief as well that the U.S. Copyright Office has even updated the procedures under Section 1201 voluntarily to make it less burdensome for individuals who want to get exemptions. So exemptions essentially renew, for example, if there's no opposition. So, I think the court did, express some skepticism that this provision that has been operating pretty well for a number of years is somehow, completely unconstitutional. So fingers crossed, because this is, again, one of the most important tools in our toolboxes in terms of protecting content online, that the anti-circumvention provisions are upheld by the DC Circuit.
So for digital content, you've already talked about how a lot of the links that are in the sort of chain of IP getting to consumers include ISPs, search engines, domain registries, payment processors, advertising networks. Karyn and Jan, if you'd like to weigh in as well, what are some examples of voluntary agreements that content owners and companies have reached with those kinds of entities in the distribution chain?
Yeah, and this is, something I would say of a success story in a way. I think if you thought you go back 10 or 15 years, you often, see very adversarial interactions between, content creators and ISPs, a lot of litigation, not to say that there isn't still some litigation out there, but, we have been able to work, I think, more effectively in the last several years with, partners in the internet ecosystem. Right now in our legal team, for example, we have a lawyer who is really primarily focused on our voluntary initiatives and outreach to, various internet ecosystem players. Whereas 10 years ago, everyone in our legal department would have been lawyers suing those potentially, actors. So I think that shows how things have changed. More recently, I think it was just last year or earlier this year, our CEO, Charlie Rivkin, did a blog highlighting some of the success stories that we've had in terms of voluntary initiatives. We've worked, effectively with Facebook, for example, on getting certain things taken down. We highlighted Google, for example, in that blog that Charlie did about our voluntary initiatives, worked fairly effectively with them. I mentioned earlier our site blocking efforts overseas, and one of the things that we've noted is, it's very effective on its own. It reduces piracy to those websites 80 to 90%. But we've also noted that when those sites that have been blocked are actually delisted by Google, so they are not coming up in search results, that actually increases or decreases by about 1.5 times the level of piracy going to those sites. So the combination of our court-ordered site blocking as well as delisting is something that has been very effective, and that is something that is a voluntary initiative that we have been doing with Google to date. Google has delisted more than 10,000 sites that we've gotten court orders for site blocking on from their search engine. So again, and that's something that we've done in the context, it's related to site blocking. So again, 10 years ago, I don't know that this would be an outcome that anyone would have imagined, that one, we would be able to use site blocking so effectively overseas, but that two, that we're actually be able to increase the effectiveness of site blocking by having a voluntary initiative with Google that delists those websites from the search engine. So that's one example of how effective the voluntary initiatives are now.
Do you have anything to add to that?
Well, it spans obviously also hosting providers where we have fast track procedures with to take down illegal websites. We are working very closely together with the payment processors where we kind of submit targets where their payment services are being used. They disconnect them. We work together with them to make sure they don't reuse it going forward. Next to having voluntary agreements, for example, this public one with donuts and RADICs, registries, registrars. So when they use those registries, registrars for their illegal service, they don't work with them, they take them off, and those websites then disappear. They might reappear somewhere else where we have voluntary initiatives with as well. And if not, then there are a whole range, to Karyn's point, of other voluntary initiatives in place that span kind of the internet ecosystem, intermediaries that support these websites. And it's important that we work together with them to kind of have disruption going on all the time. That's very important, next to everything we just talked about, by going after these operators and use every tool in the toolkit to address them wherever they may be.
The money that's involved here in terms of what's available to those who participate in piracy, a lot of it comes from advertising. What sort of voluntary agreements are there in the advertising space that help to address this, try to cut off some of the money supply?
Yeah, I would say the most well-known and effective initiative is the Trustworthy Accountability Group, or TAG, which is essentially a good housekeeping kind of seal of approval that essentially keeps good ads off bad sites. The group that is involved in this has more than 700 members in the advertising industry. They share best practices, promote brand safety, and so that's something that I think has been very, very effective in terms of trying to ensure that, again, advertisers aren't unknowingly contributing to profits from illegal websites.
If anybody wants to learn more about these voluntary initiatives and agreements aimed at piracy, I've put a link in the chat to an excellent report released by the Information Technology and Innovation Foundation, which drills down on this and gets into a lot of the things that were discussed here. Also mention, again, if you have any questions for our panelists, please do put that question in the Q&A function. I'd like to end my questions today about asking about the role of consumer and policymaker education in the fight against piracy. Could either of you describe what MPA and its partners have found impactful in explaining the harm of copyright infringement to entertainment audiences, elected officials, regulators, et cetera?
Going back to kind of my example earlier about, the movie Moonlight, which was a letter that was sent by folks within the film industry directly to members of Congress. I think what works in terms of education really is explaining that real world impact. Again, we can throw the numbers up there. We say, billions of dollars lost, but when you actually have an individual artist, an individual film producer come in and say, I'm not going to be able to make my next film because of piracy. I'm not going to get greenlit by a studio. When you actually have, folks, just your average middle class workers who are saying, I'm not able to continue my job in the film industry, providing as a hairstylist or as a makeup artist because there are less films being made due to piracy. Those, I think, take it out of just a numbers game and that people can kind of ignore and really have a personal face to it. So I think one of the most effective ways of educating consumers and policymakers is actually having them hear, not necessarily from the lawyers, so me speaking a little bit less, but actually hearing directly from the creators who are involved in the process about the effect of piracy and how important really having strong copyright laws are to ensuring that, creative works are continuing to be made.
Anything to add to that?
No, I think Karyn has covered it. I mean, I covered DCA, the risks that are there, and consumers can read those reports, and that there are serious risks out there for them as well. And I think both are important points. So nothing further to add. Thanks.
Is it fair to say that because of the way that especially the movie industry has changed in terms of the way that products are delivered post-pandemic, the economics are such that the profit margins are probably narrower than they've ever been. So in that sort of situation, streaming has definitely increased the need to fight piracy because of the conditions that sort of currently exist in the industry. Is that a fair statement?
Yeah, I mean, I would say, I mean, it's fair. I mean, I think again, as technology changes, as streaming becomes more of an everyday occurrence, as you have, piracy again will use that same technology, and you're gonna become, it's one of the things that we often talk about is it's very difficult to compete against free, and you have a lot of streaming services out there, a lot of options that compete against each other, but they're not going to be able to compete effectively against an illegal streaming service, and those services are not going to be able to continue to grow where you have more consumer choice when you have those illegal services. And we see that a lot, especially in emerging markets, where people, it's an unfortunate catch-22, because you have consumers who want more choice and more variety, but then it's more difficult for those legitimate services to go into those markets because there's so much piracy. And so, you do really have to have that strong, foundational copyright law, so that you can have legitimate services coming into those emerging markets and providing the wide variety of services that consumers really want.
I think we will wrap it up then. Definitely appreciate both of you joining us today. Hopefully everyone who joined us learned something along the way, and that there are serious issues to be considered here, as well as serious economic harms when copyrights aren't being respected and rising to the level of organized crime being involved. So thank you, Jan, and thank you, Karyn, very much for joining us today. We'll be doing more programs in this series as the year goes on, and hopefully everyone will continue to tune in. Thanks again.
Thank you.
Thank you for having us.
Thank you. Bye-bye.